All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
For many Filipinos, purchasing real property for the first time is a significant life event. The journey to becoming a property owner, be it a house and lot in the suburbs, a piece of agricultural land in the province, or an investment in a condominium unit, can be both exciting and unsettling. While understanding the legalities and processes involved in acquiring real property may overwhelm most, observing due diligence is but necessary for both first-time and experienced buyers. The Supreme Court itself has constantly emphasized the need for real estate buyers to exercise prudence and due diligence in determining the status of titles of properties they wish to acquire. In the case of Manilese versus Estate of Spouses Ferreras, the court stressed that prospective land buyers must check both the title of a property and its records in the Registry of Deeds to avoid fraudulent transactions. The case involved two parcels of land in Angeles City, originally registered in the names of spouses Narciso and Ofelia Ferreras under valid Torrens titles. Years after the passing of the spouses Ferreras, a certain Karina Pinpin was able to procure titles to the properties using an affidavit of loss that declared lost the owner's duplicate copies. Pinpin managed to have owner's duplicate certificates of titles issued in her name, even if the original ones were never actually lost. By virtue of the reissued titles, a deed of sale was executed in 2009 between the spouses Orencio and Eloisa Manilese on one hand and Pinpin on the other. Pinpin presented to the Manileses two certificates of title purportedly showing that both deceased spouses Ferreras signed the deed of the property sale in her favor. The properties were later transferred to the Manilese spouses, who claimed to be buyers in good faith and for value. When the estate of Narciso and Ofelia Ferreras discovered the unauthorized transfer, it filed a case to nullify their issued titles, claiming that the two properties still belonged to the estate. The Manileses countered that they were innocent buyers, relied on clean titles, and had no knowledge of the fraud. In purchasing real property in the Philippines, what should the considerations be of a buyer acting in good faith? How do the courts apply the principles of good faith and innocent purchaser for value in disputes involving sale of real properties? How important is the observance of due diligence when it comes to protecting one's right as a real property buyer? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 21st of November 2025, and today we talk about land titles and what buyers should do before purchasing lands within the context of the case of spouses Orencio Manilese and Eloisa Manilese versus the estate of the late spouses Narciso and Ofelia Ferreras, GR number 254046. This case was penned by Supreme Court Associate Justice Alfredo Benjamin S. Caguiwa and decided by the Supreme Court 3rd Division on November 25, 2024. And joining us again is Court of Appeals Associate Justice Jose Lorenzo R. De La Rosa, a member of the Remedial Law Department of the Philippine Judicial Academy. He used to be a presiding judge of a family and exclusive land registration court in the city of Manila. Hi, Justice Jolo. Welcome back to the Supreme Court podcast.
Good day to you, Attorney Mike. Thank you for having me again.
All right, thank you, Justice. Let's talk about this case of Manilese versus Estate of Spouses Ferreras. There was a dispute here which involved a reissued or reconstituted title. But what's a reconstituted title, and how is that different from the original title or the owner's duplicate?
Actually, it's good you ask, no? Because in my experience, there's a tendency to interchange both concepts. So technically, when we speak of reconstitution, okay, it is the reconstitution of title on file with RD. So we note now that your transfer certificates of title, you have an owner's duplicate copy.
Yes.
And you have a copy on file with RD. So when we speak of reconstitution, I mean, because sometimes, of course, we know in our cases that it's not the title of the pleading that governs, but the prayer. But they would always pray for reconstitution of the owner's duplicate copy of title. But really, technically, when we speak of reconstitution, we are only referring to what? The reissuance of the title which was on file with RD, which may have been lost, may have been destroyed, cannot be located. On the other hand, if an owner loses his or her owner's duplicate copy of title, it should really be a petition for issuance of owner's duplicate copy of title, or petition for issuance of a new owner's duplicate copy of title.
So technically, reconstitution will only come in if the original records in the Register of Deeds are lost, like maybe in the case of a fire.
If the title on file with the RD is lost. Okay. If allow me,
Please go ahead.
For the benefit of your listeners. So the title, and since you mentioned fire, it just reminded me of two types of reconstitution. So again, reconstitution, what is lost or destroyed, and from my experience, what may have been eaten by termites, okay, or you have the remnants that are there, is that on file's RD. Owner's certificate of title on file with RD. We have two types of reconstitution, and of course, reconstitution governed by your Section 10 of your Property Registration Decree, PD 1529, and your Section 110 has been amended by Republic Act 26. So you have two types of reconstitution. You have your administrative reconstitution, and you have your judicial reconstitution. So administrative, it is with the Register of Deeds, it is with the LRA, which will cause such reconstitution. When you speak of judicial reconstitution, it is you file a petition with the court. So administrative reconstitution is allowed if there was a significant loss of titles on file with a particular RD. So it may have been lost through fire or inundation, flooding, or any force majeure as determined by the administrator of the LRA. So we've had that instance, some case law will tell us, like in Quezon City, there was a fire. I think some case will tell us lost because of the effects of World War II. So significant. And when we speak of significant, it's significant in the sense that no less than 500 titles were lost, and at least 10%.
Right.
If it doesn't meet the criteria, you have 200 lost, maybe 499. They have to file for a petition, judicial petition, for reconstitution of title.
And this will be on an individual basis, individual title.
Yes, and this is with the courts, these are with the regional trial courts. Jurisdiction is not, there's no more one exclusive land registration court by provision of PD 1529, Section 2. All regional trial courts have jurisdiction to hear and decide cases for land registration and cadastral cases. In this case, for reconstitution of title.
So in this case, in Manilese, how should we properly classify what happened here?
What happened here was that there was a loss, supposedly, allegedly. There was the owner's duplicate copy was lost. So, as in this case, Pinpin was able to have a new owner's duplicate title of the Spouses Ferreras, deceased Spouses Ferreras, issued, and title was issued in her name. And after title was issued in her name, this is what she presented to our petitioners in this case, Spouses Manilese, and for which they claim to be innocent purchases for value.
And the question here, really, Justice, is if you are presented with the reissued title, is it enough to look at the reissued title? In general, what's the rule on this?
Okay. If let's go first to Section 109. It's the provision in PD 1529 which deals with issuance of a new owner's duplicate copy of title. Okay. So the first task really for an individual is once you lose the owner's duplicate copy of title, is what? To make it known to everyone. Because really, possession of the owner's duplicate copy of title can bring about transactions. If you have a buyer or maybe you want the mortgage to property, what does the buyer ask for? Do you have the copy of the title?
Owner's duplicate.
So once you have a copy of title, really you can have transactions with it. Okay? So, as a matter of course, if one loses his or her title, Section 109 instructs us, make a notice under oath, affidavit, okay, under oath, and have this annotated with the Registry of Deeds. Okay, and with the said annotation, everyone is notified that the owner's copy of title is lost. So therefore, all those who deal this property, be on guard. You may have been dealing with something that was stolen, what have you. So in this case, there were supposedly annotations of the lost title. Supposedly, the deceased. I want to emphasize the word deceased.
Yes.
The deceased spouses Ferreras lost the title, for which the corresponding annotations were made. Titles involved in this case, and because of such, of course, the next step is, of course, let's go to the steps. You file a notice under oath, which is registered, and it's not the RD which will issue the title. It has to be through a court proceeding. There should be a declaration by the court. No, your notice under oath is really a warning to everyone. But the RD will not, issue a new title.
Yes.
There must be a judicial determination that indeed.
So you file a separate case for that.
Yes, you have to file a separate case, for which you file a petition for reissuance of any owner's duplicate copy of title, issuance of any owner's, but definitely not reconstitution, as we mentioned earlier.
Yes.
So there must be judicial determination, and it's the court, after assessing the evidence, which will declare indeed the owner's duplicate copy of title is lost. RD, please issue a new owner's duplicate copy of title in favor of this person, the petitioner. So in this case, there were annotations. There was supposedly a court decision stating that indeed lost and ordering the RD to issue a new owner's duplicate copy of title. Okay? And once the RD issues a new owner's duplicate copy of title, the annotation should still be there. It's not automatic. This because the annotations warned to the entire world that indeed it was lost. It's still there. You can only have this cancelled if you file a petition for amendment or cancellation under Section 108. But it should be there. So in this case, Pinpin was able to successfully have a new owner's duplicate copy of title, supposedly because of a court decision. Well, I have my experiences in that in Laguna. And this was the basis for her to have it transferred in her name. So I transferred in her name, and lo and behold, the annotations of what happened, the notice of loss, the court decision, should have been annotated on the title.
It was not.
And that was the duty of the Register of Deeds. It wasn't there. And it wasn't there, and this was really the cause, and eventually it was transferred to the spouses Manalese. So this was the cause of spouses Manalese telling that, hey, I looked at the title, it was clean. Now to answer your question, should you parties be careful with regards to reissued titles? So in this case, you can say that there was no notice. But what does the Supreme Court instruct us? It's not just the annotation on the title itself which should govern. Okay, the diligence that is now required is what? Before, kasi old cases, it's whether you look at the registration book or the title itself. And since I'm Supreme Court, it's not really or. But good diligence tells us that what? You look at the title and you look at the registration book. Because the registration book, that's the primary entry book. Okay, now it's computerized. You have your primary entry book. So the duty is on the buyer to look not just at the title. Go to the Register of Deeds. Find out ano yung mga entries of title in that case. And of course, if there's a reissuance of title, be on guard. And in this case, there was also a suggestion of the Supreme Court. Look at the case. What happened to the case? Was there really a case?
Right.
Because years ago, I've had experiences when there was supposedly a case annotated, but tignan mo, wala yatang kasong
there
final.
was no case, right?
That's years ago, 20 years ago.
And in this case, Justice, maybe let's just go through some of the telltale signs, so to speak, because the Supreme Court was saying this should have alerted you, right? For example, the sale of properties in this case was executed in 2009, but the supposed sellers had already passed away years earlier. So should this have alerted the buyers?
Well, ganito, in the first place, should they have known that they were, and this is, of course, we're doing this for the benefit of our title landowners, or those who really want to spend their hard-earned money to buy real property, title property, assured of their ownership. Well, in the first place, no, the spouses, I think the husband died in 1995 and the wife died in 2005. So maybe a cue for an individual release. When was the title issued? If it was issued 1970s, 1980s, I think you have to inquire whether the parties are deceased already. In the first place, really, the warning given by cases, as mentioned in this case of spouses Manalese, tell us that what, diba? The first thing to note, no, taking from the case of spouses Bautista, no? Supreme Court tells us, no, the case of spouses Bautista versus Silva, as penned by Justice Austria. What is the diligence required? No? There's three duties, no, on the part of a buyer. First, what? They should find out if is the seller the registered buyer. And the second test is who is in possession of the property? Is it the seller? Diba? And the third, to determine, okay, whether at the time of the sale, the buyer was aware of any claim or interest of some other person or any defect in the restriction of title, as well as the capacity of the seller. So in this case, diba, if you are the buyer of the property and it's not the title holder who is selling the property, I think you should be on guard. Where is the title holder? If there's a disclosure that they are deceased, I think a buyer should find out when did they pass away. More so, who are the heirs of the title holders? Are they complete? Because we know, diba, at the moment of death, okay, property transfers to the heirs. I mean, just putting it, the children, they become co-owners to the property.
Right.
And if they're not buying it from all the co-owners, what they're buying is just a share.
Yes.
Diba? Not the entire property. Diba? So, really, first thing I think a buyer should do, are you the seller of the property?
Right. And even if you can show a title, you also look into how you obtained that title.
Yes. Diba? How did you obtain such title? Diba?
There's a suggestion here, Justice, that the Supreme Court is saying you should also look at the price for which the property was sold, because here there was supposedly a gross inadequacy of price. There was an undervaluation supposedly from 3.3 million to just 250,000.
Okay, so one of the claims of the petitioners here, we're buying good faith. We bought this for value. And this was an indicia on the part of the Supreme Court telling us that the value for which you have bought, okay? Pin claims that she bought the property for about 250,000,
yes,
thereabouts. And the petitioners here claim, including the deposit, around, they bought the properties for about 3 million.
3.3 million.
3.3 million, inclusive, a total of 3.3 million. So, really, if you were the buyer, if you were the spouses Manalese, wouldn't you think, why did you buy it? It's something that the Supreme Court, you should have inquired. Why did you buy it for 250 and yet you're selling it for
3.3?
Almost 10 times the value of the property. And there was an excuse here, and this is something that's interesting, no? Supreme Court, quoting the case of Kusi. What does it tell us? There's a practice, no? I'm sure you may be aware of this. When some individuals buy property, they have sometimes 2 deeds of sale. Diba? Where there's one with lesser value. Of course, they presented their assessor showing that it's worth 550,000. But eventually, I think the trial of the case, there's an admission that, or it came out, no, it's a finding here in this case, that they did so to avoid tax liabilities. That's the practice here, no? And I think this is a good warning for your listeners. To avoid payment of taxes, let's state in this deed of sale that a lesser amount, and ultimately maybe have another deed of sale, or we have something that's not yet in the paper. This is how much I'm actually going to pay. Is this an indication of good faith? Sabi ng Supreme. What did the Supreme Court say? Who are you defrauding here? You're defrauding the government of taxes. Therefore, how can you say that you're in good faith?
Right.
So really, gross inadequacy in the price, there's nothing wrong with it really. But if it's really, its purpose is to defraud the government and really reasonable the circumstances would impel you to inquire, and you did not do so, these are indices of to erode the good faith, the supposed good faith of an individual.
So, Justice, what key facts did the Supreme Court actually rely on to conclude that the supposed transfer of the Ferreras properties to Karina Pinpin was fraudulent? Of course, we discussed the price, we discussed the earlier death of the supposed sellers, but what were the facts that the Supreme Court really relied on to make that conclusion?
Okay, they claim here that, they're innocent purchases for value. We bought the property from Pinpin, title holder. She was in possession of the property, and nowhere did they see Ferreras in this case. Okay, so we relied on title.
Right.
Maybe we've brought up yung curtain principle, mirror principle, and what does that tell us? Diba? You rely on title. These principles bring about the really strength to our torrent system. But what is the Supreme Court telling us? Supreme Court is telling us, in my view, is that you just don't rely on title, meaning the owner's duplicate copy of title. Okay? You should also what? Look, as I mentioned earlier, you should look at the registry itself. You look at the primary entry book. Because that is where you'll find out. That's where you will see the history of the case. And that's the diligence that is required. That is what will make you a buyer in good faith. Okay? Had the Manilese, spouses Manilese done so, they would have seen that there were entries that there were lost of claims of lost owners' duplicate copy of titles. It was made all in 1 year, and it would have aroused suspicion. So they didn't do so, and really a factor also in this case. Maybe jumping ahead. There was no negligence on the part of the Ferreras. They were still in possession of the owner's duplicate copy of title. They were not culpable or negligent in losing it. So this really militated against the spouses Manilese.
Had they checked?
It was never lost. The owner's duplicate copy was never lost. Maybe just to put things in context. The owner's duplicate copy of title was never lost. It was always in possession of Ferreras. And there was just a fraudulent claim on the part of Pinpin that it was lost. Diba? So, really, for me, pardon me, if the court did its diligence, in this case, supposedly there was a decision. Just put it there. So if the court did its diligence, it will just find out that it was never lost. And it could have prevented this. Well, but what's nice with this case is that we learn lessons. But yeah,
right.
But the hassle, diba? And certain, you as a buyer you want to be assured of your title over the property.
But also interesting here, Justice, is the role of the Registry of Deeds.
Yes.
Because the Supreme Court said that the circumstances should have alerted the Registry of Deeds to conduct the necessary investigation and examine its records. What institutional safeguards failed here, and what responsibility does the Registry of Deeds have in protecting the integrity of the torrent system? And what are also the limitations to what it can do?
What's interesting in this case, certain attorney Manikis was the supposed Register of Deeds. And if I'm not mistaken, a Register of Deeds must be a member of the bar. Okay? The fact that they are members of the bar, they should comply with the law. Diba? They should ensure the strength. They should really put forth and put strength to our torrent system. In other words, no foolishness on their part, no unwanted dealings on their part. You are members of the bar. And therefore, you're bound, as we all are, by our code of professional responsibility and accountability. Okay? In this case, our Register of Deeds did not put the annotations on the newly issued titles. Had he done so, which he should have done so, then really, everybody would have been forewarned.
Manaleses could have been alerted.
Yes, they could have been alerted. So really, it's what? Do your duties. Remember, that you're members of the bar. And as members of the bar, you have the duty to uphold this. I did mention that, Attorney Manikis, because what's interesting here in this case is that there was a referral on the part of the Supreme Court.
Yes.
The IBP. Yeah. Please investigate, Attorney Manikis, because, you can see that there was wrongdoing in this part. There is possibly, not to say that there is, but there's possibly a violation of our CPRA. No? So, and I think that's something that the courts should do. Something that I used to do really as a trial court judge. We should be proactive in that sense. If you know of any falsity, put it in your decision.
Right.
Refer it to the proper office.
And Justice, what about the buyers who lose to fraudulent sellers? What remedies do they have? I mean, they can file for action for damages?
Yes, I think they can definitely file for action for damages. No? And of course, reimbursement, if you think of it, no? From the fraudulent seller. And we're talking about fraudulent seller here. So I think there are also possible criminal cases. Maybe, possibly estafa. If there was any falsity, for me, any falsity in the notice of loss, that could be perjury. That's a material falsity under oath. If there was indeed a court case and there was testimony as to supposed circumstances surrounding the loss of the owner's duplicate copy of title, that's again false testimony. Again, subject to criminal cases. What the buyer can also do, part of one of the principles, we have 3 principles which would bring about indivisibility of our tolerance system. We have the mirror principle, the curtain principle, as discussed, of course, and we also have the insurance principle. Okay, under PD 1529, we have the assurance fund. So if there's any negligence or fault on the part of the Land Registration Authority bringing about titles, then individuals can claim from such assurance fund.
On the part of the judges, Justice, how should they handle petitions for reissuance of a lost title when the proof of loss is questionable?
Okay, I guess in this case of Manales, and as it quoted other decisions of the Supreme Court, in the sense, it's the same reconstitution, reissuance of title. In this sense, also, I can also say that both for reissuance of owner's duplicate copy of title or reconstitution of, judges should be extra vigilant. We have guidance from jurisprudence. If I may say, I've read a lot of these cases, and sometimes we have siblings who inherited the property, and there's a dispute between them, and we have one sibling wanting to have his or her own copy of title, or maybe wanting to sell, supposedly they think, the entire property, but their share really, and they file a petition for issuance of a new owner's duplicate copy of title. We send the corresponding notices, and lo and behold, here comes sibling with the owner's duplicate copy of title. And the case of Alcazar versus Arante, as well as 2012 case, and related cases will tell us that if the owner's duplicate copy of title is not lost, the court never acquires jurisdiction over the case. Judgment is void. As a matter of fact, here in the Court of Appeals, we have a lot of cases for annulment of judgment under Rule 47. Coming from really lack of prudence in deciding cases for issuance of owner's duplicate copy of title. I've had an instance wherein one of the creditors filed the petition and really taking guidance, I'll tell you later, taking guidance from jurisprudence. We notified the registered owner. She never authorized the supposed attorney, in fact, and never authorized her agent to file the case. And the person was merely doing so because she wanted to get the property and because of the loan. Hence, we dismissed the case because it was never lost. So, what is the guidance really from judges and something that is taken from jurisprudence? Okay, first and foremost, cases of spouses Ramirez versus Registry of Deeds of Nueva Vizcaya. What does it tell us? It's a 2019 case. If it's the registered owner who's filing the petition, well then good. You have assurance. But nonetheless, you still have to, of course, that will go to the evidentiary matters. You have assurance. Okay? But what if it's a buyer of the property? In this case, that you can say maybe what happened to Pinpin. It's a buyer, supposed buyer of the property. Yes, being a buyer of the property, they have interest to file the petition because you're the buyer. Rights have been transferred to you. But spouses Ramirez tell us that and this is something I think judges should remember, is the registered owner, or in case of their death or absence, their heirs remain to be interested parties. They should still be notified of the proceedings.
Right.
Diba? If this was followed in this case of spouses manalese, diba? The deceased spouses would have been notified because they're interested parties. Or if not, the heirs would have been notified, and it would have prevented that. So really, notwithstanding the fact that yes, you're a buyer, you have interest to file the case, title holder is still entitled to notice. In the absence, the heirs are entitled to notice. Next, of course, usually what happens in this case, of course, notify all interested parties. I've told you, it's just one of the stories, no, that I told you na the title will come out. Okay, it may be burdensome, but you have your video conferencing, you may make use of that. Now, what happens usually, sometimes it's ex parte, there's no oppositor. Okay, and even if it's the title holder, the court, notwithstanding it being an ex parte proceeding, okay, that doesn't mean that the rules on evidence are suspended.
Right.
The court should satisfy itself first of your interest of the property, the facts and circumstances surrounding the loss of the owner's duplicate copy of title. Okay, if they do so, then by all means issue. If you don't, then deny it, because Supreme Court tells us in the case of PBCom versus Registry of Deeds of Benguet, there's no res judicata. If the witness is not sufficient, dismiss it.
Right.
Let them refile it with when they have a competent witness who's able to tell of the circumstances.
And Justice, just to close our discussion, what should buyers keep in mind when dealing with reissued titles, or maybe even reconstituted titles, or suspicious land transactions? What should they always keep in mind? Okay.
Let's go first to a buyer. Okay, you're parting with hard-earned money, diba? And you're doing this, as maybe part of investment, something to leave to your children. Do not let excitement, okay, overtake the necessary prudence. Okay, let's go through what the Supreme Court tells us. Are they the buyer? Are they in possession of the property? Are there circumstances which would arouse suspicion? Okay, and will this go to the Registry of Deeds? In this case, go to the primary entry book. If it's a reissued owner's duplicate of copy of title, be on guard. What were the circumstances surrounding the case? Maybe it can go as far as going to the supposedly decision rendered by the court.
Yes.
Okay, which brought about, was there really a decision? Who filed the case? In that regard, we can take into consideration the decision of the Supreme Court, diba? Aside from that, aside from verifying the origin history of the title, engage the services of a geodetic engineer, because sometimes you have cases, diba? You think you're buying the property, but
it's a different property.
There's overlapping of the property. Who is in possession of the property, right? Conduct an ocular inspection of the property. Inquire from your neighbors, adjacent property owners, if indeed, if they hear of any stories, of any, thing which would arouse suspicion or interest over the said property. Put up signs, okay, for over the sale of the property. And of course, once property is titled in your name, and I take this really from my grandfather, and if I may say it in Filipino, ingatan mo ang owner's duplicate copy of title mo. Don't put it in a drawer. Don't put it laying around. Keep it. Because really, once you lose the owner's duplicate copy of title, and there's negligence on your part, your title may be defeated by an innocent purchaser for value. It's different if you're holding the owner's duplicate copy of title. So,
all right. Thank you very much, Justice Jola. What a good reminder to everyone listening to be always on guard when dealing with your owner's duplicate title.
Yeah, this is hopefully not to for them to lose confidence, but sa akin, to exercise the necessary diligence.
Right. There are so many things to fix with our land registration system. I understand there are efforts in the Supreme Court to do this. So
yes.
Possibly in the next few podcasts, we can discuss that in the future.
Yes.
What the Supreme Court is doing to address this issue.
It's something that has to be undertaken, really.
All right. Thank you very much,
Thank
Justice
you very
Jola.
much. Thank you. Mabuhay ka. Thank you.
If you wish to read the full text of the court's decision, please visit the Supreme Court website or the Supreme Court e-library and search for spouses Orancio Manelese and Eloisa Manelese versus estate of the late spouses Narciso and Ofelia Ferreras, GR number 254046. Here's Steph Atendido Beltran, Supreme Court Information Officer, for this week's updates.
From the Supreme Court of the Philippines, here's the latest. On Tuesday, the SC On Bank has ordered the respondents in the very urgent manifestation filed by former President Rodrigo Duterte and Senator Ronald De La Rosa to comment within 10 days. The manifestation was filed in connection with a petition challenging Duterte's arrest and the Philippine government's cooperation with the International Criminal Court or ICC. It alleged that Ombudsman and former Secretary of Justice Jesus Crispin Remulla has publicly stated that an ICC arrest warrant had already been issued against De La Rosa. The SC also denied the very urgent motion filed by Duterte and De La Rosa seeking to compel the production of the alleged ICC warrant which Remulla claimed to possess according to various news reports. In another case, the SC has ruled that wealth acquired by a public officer during their time in office that clearly exceeds their lawful income is presumed unlawfully acquired and may be forfeited even if registered under the names of other individuals. The SC's 3rd Division, through Associate Justice Japar de Maampao, upheld the forfeiture of properties, bank deposits, and investment accounts in the name of the late retired Lieutenant General Jacinto C. Ligot, as well as assets traced to him but registered under his wife, children, and relatives. The SC upheld the Sandigan Bayan's ruling, which found that the properties, deposits, and investment funds were unlawfully acquired. It noted that General Ligot's wife and children did not have independent income sources but still owned properties and held significant bank and investment accounts under their names. The SC held that circumstances indicate that General Ligot was the true owner of the subject condominiums even if the legal titles were in other people's names. Under Republic Act No. 1379, properties of public officers are presumed to be illegally acquired when they are manifestly out of proportion to their lawful income. Meanwhile, on November 19, retired Associate Justice Francis Hardalaza expressed optimism that the SC under the leadership of Chief Justice Alexander Esmundo can make speedy disposition of cases an achievable reality at the 19th Metrobank Foundation Professorial Chair Lecture held at the On Bank Session Hall in Manila. Organized by the Philippine Judicial Academy in partnership with the Metrobank Foundation, Inc., the lecture focused on Article 8, Section 15 of the Constitution, which requires the SC to resolve cases filed before it within 24 months. Justice Hardalaza noted that the SC has taken a significant step towards complying with a constitutional provision, citing reforms such as amended sections of the internal rules to speed up disposition of cases. He added that the court now has more resources at its disposal. Associate Justice Josep Lopez, in his closing remarks, said the court has determined that constitutional deadlines could now be observed for incoming cases without disrupting the disposition of older matters. He added that the lecture has provided context on the causes of delay, such as institutional factors, not only in the SC but in other parts of the justice system. On Thursday, Associate Justice Maria Filomena Singh delivered the welcome remarks at the United Nations Office on Drugs and Crime or UNODC high-level meeting on judicial integrity for South and Southeast Asia held in Makati City. Justice Singh highlighted that judicial integrity is not a mere philosophical ideal, but a living ethical commitment, which requires rendering decisions purely on law and evidence, unclouded by personal biases, political pressure, or corrupt influence, as well as courage to resist impropriety in all its forms. She also stressed that the rule of law thrives only when the public believes that justice is dispensed fairly. The two-day meeting, attended by Chief Justices, Deputy Chief Justices, and senior judicial leaders from across South and Southeast Asia, featured dialogues and sessions tackling judicial integrity issues. On Friday, November 20, the Office of the Court Administrator celebrated its 50th anniversary at the SC compound in Manila. The celebration was led by Court Administrator Maria Teresa Gomez Estuesta and the Deputy Court Administrators and other OCA officials. In attendance were Associate Justice Jose Mayres Marquez and Raul Villanueva, who were both former court administrators. Acting Chief Justice Marvic MVF Leonen attended the celebration. Also in attendance were Associate Justices Jose Mayres Marquez and Raul Villanueva, who were both former court administrators. Pursuant to Presidential Decree No. 828, as amended by Presidential Decree No. 842, the OCA was established in 1975 to assist the SC primarily in the exercise of administrative supervision over all courts, as prescribed by the Constitution. The Philippine Muslim Judges Association, or PMJA, held its inaugural national convention on November 13 and 14 in Sulu Province, focusing on the theme Fair, Equal, and Inclusive Justice, Essential Foundation for Peace and Prosperity. The two-day gathering brought together Court of Appeals justices, trial and Sharia court judges, and other court officials. It discussed the Bangsamoro justice system, the special rules governing Sharia courts, and recent developments on Sharia, procedure, and jurisprudence, followed by a session on procedures and cases in the CA. Chief Justice Alexander Esmundo led the Philippine delegation in attending the 12th Council of ASEAN Chief Justices meeting in Singapore on November 13 and 14. During the meeting, Chief Justice Esmundo passed on the chairship of CACJ to the Honorable Chief Justice Sundaresh Menon of Singapore, which marks his third tenure as CACJ chair since its founding in 2013. The CACJ meets annually to tackle issues of common interest and concern to member judiciaries. The Philippines hosted the 11th CACJ meeting in Cebu last year. You are now up to date with the Philippine Supreme Court. I am Tifa Tendido Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast as well as previous episodes on the Supreme Court Public Information Office's accounts on Facebook, YouTube, Spotify, and Apple Podcast. This podcast episode was produced by the Supreme Court Public Information Office, with Attorney Mike Navalio as overall in charge of production, Attorney Karen Martinez as supervising producer, J. Rempilio, executive producer, Tiff Atendido Beltran, producer, May Sibal, Attorney Ian Aldueso, Attorney Sheila Reyes, and Ramir Simbahon as researchers and writers, Brian Austria, Don Ryan Balza, and Vinny Laraño as audio editors, Lawrence Olaño and Austin Aliscat as video editors, Bea Batong as graphic artist, and Tyke Flores and Jerome Batumalake as web editors.